Hello, welcome to our next lecture, Miranda v. Arizona, 1966 case. We're moving along, of course, in the 20th century, and we're moving into criminal law, very important law that was relatively new, considering where we've come from, but nevertheless has had a tremendous impact on our society. You may even recognize this case name. Maybe you've recognized some others, but the Miranda rights. If you've ever seen a movie, and oftentimes I think it's a joke at this point. I'm trying to come up with examples off the top of my head, but usually it's like new cops or something, right? And they're arresting someone, and they're having to figure out how to give this spiel about you have the right to remain silent, and you have the right to an attorney, and anything that you say can and will be used against you in a court of law. And if you cannot afford an attorney, then the court will provide one to you. So this is where that concept comes from. Those Miranda rights comes from this case. There is a lot to unpack. There's a lot to kind of analyze and ultimately pull out some of the concepts about justice and how is justice administered in our legal system. So we are, of course, nearing the end. We're coming up quickly to the end of the semester. I anticipate that a lot of the weekly assignments have given you opportunity to discuss these big concepts, these foundational concepts of law, to look at it, of course, through our Christian worldview and analyze a variety of aspects that we've covered in these courses. And then, of course, the big final will be we're closing in soon. So we will have plenty of time to talk about the final, have plenty of time to go over the requirements and the expectations. I truly hope that this has been a great experience for you as you're able to sort of see how American jurisprudence has been created, where the common law or the modern law originates from, and really how it continues with us today. So with this case, like I said, we're getting to the criminal law aspect, a newer concept for us, but nevertheless same sort of foundational principles. So this is a new one, a new Latin phrase. I hope that you all can say this better than I can. I'm going to call it the nemo principle, or the nemo tenetur principle. And it comes from a very old concept in English common law, where no man has to accuse himself. So again, we're dealing with criminal concepts here. We're going to deal with the Fifth Amendment and the Sixth Amendment primarily, but it's important to lay a foundation here and think through this from sort of a philosophical or theoretical perspective. So I think the court gets into the history of this a little bit. So for our purposes, we can kind of brainstorm and think through this concept. So let's just suppose that, we're living back in the day, and, let's say that a guy steals a goat, and he steals a goat from his neighbor, but no one saw this guy take the goat. And so let's just kind of, for simplicity, let's say there is relatively understood law enforcement in place, and so this goat stealer goes and gets arrested and put in prison. Let's just assume there's all sorts of good criminal procedure that is afforded to this man. But there's still a concept of you're going to be tried. You're going to have your day in court. That's not, of course, always the case, depending on who you were back then, where you came from, perhaps the nature of the crime, who accused you would also have been a huge factor. But again, just for simplicity, let's just stay with this concept of a wrong has been committed. Now, when we're going into court and we're going into a jury of our peers, perhaps, or a judge, more times than not, there's this question that gets brought up: is how do you know? There's an accusation that was made, and now we're going to proceed with the prosecution. Namely, you stole a goat, and the penalty is whatever, a $500 fine or a year in prison or something to that effect. There's a punitive aspect of this crime. So I would hope what starts turning your mind is, well, wait a second. We're assuming that this guy took the goat, but no one saw it. Okay, what's important about someone witnessing, right? Someone seeing this act being done. Well, it tends to prove that he, in fact, committed this crime, and he should deserve punishment, right? He should deserve imprisonment or the fine or both or whatever else may be. Okay, so if no one saw him take this goat, and we only have an aggrieved neighbor accusing and saying, this guy, my neighbor, took my goat. Well, okay, guy, how do you know? How do you know this guy? How do you know your neighbor took this goat? Well, I just have a good feeling about it. Or I think that he is a thief. Or I heard from my other neighbor who heard it from her cousin that this guy may possibly steal goats. This is the concept of evidence. When we're not really going to dive into this area too much. It's a fascinating study. If you're interested in how evidence is compiled and brought together to prove up a case, by all means, we can discuss that outside of our class time. But it's a principle here of how do you prove something. So to continue with our goat story, right? Guy takes the goat. He's before the judge. And a sort of immediate next question is, how do we know this guy actually took the thing, the goat? We have a neighbor who's probably grieved at his neighbor for a variety of reasons. And so it's easy for him to pick on him and accuse him and say, you took my goat. But we operate on principles of fairness and justice. And so when we look to and see that there is a wrong that's been committed, namely that the guy's goat has gone missing, then we'd like to have evidence in place to prove that the guy who's been accused, the criminal suspect or the criminal defendant, did in fact steal the goat. Okay, fair enough. So why don't we just say, hey guy, did you take the goat? We can do that. We can absolutely do that. What do you think is likely to happen, though? The guy's probably going to be like, no, I didn't take the goat. I don't even know what a goat is, right? He probably is prone to defend himself. And defending oneself typically looks like lying. And we don't like lying. We don't like lying in the court of law. We don't like lying kind of across the board, really, because we want the truth to come out and we want justice to be done. And so if lying is made available, then how are we supposed to do anything about anything, right? It just comes to a matter of he said, she said, right? You took my goat. No, I didn't. Now what, right? Now what? Now what do we do with that concept? So in crimes, there's still an element of criminal defense. In other words, it's not sufficient for someone just to accuse someone else and then boom, let's lock them up, throw away the key, fine them, whatever else it may be. Now, of course, throughout history, again, depending on who made the accusation, who was the accused, what was he accused of, I mean, that varied. That concept of criminal offense varied widely, right? Let's go back to Solomon real quick. Solomon and the two prostitutes. There's a baby. Each woman had a baby. One baby died. The other woman took the baby from the one woman. What happens? Bickering, right? She took my baby. No, I didn't. So what is King Solomon supposed to do about that? Obviously, the woman that took the baby wasn't about to say, yeah, actually, no, I did. I did do that. If people just couldn't tell lies, fantastic, right? We'd be in such a better world. We live in a fallen world. People lie. I think it's Out of the Silent Planet, C.S. Lewis, the Nyarsa, is that the right phrase? But they call it bent. They don't even have a concept of lies. It's just kind of a bent. It's not straight. It's just kind of bent. So we're living in a fallen world. People don't tell the truth. People lie. And we know that. We know people lie. Okay, so we're back to the goat analogy. A guy takes the goat. We say, hey, guy, did you take the goat? He has the opportunity to lie. Rather than go down that path, though, a principle is established, this nemo tenetur principle, that guy doesn't have to accuse himself. We know he'd probably lie anyway, so rather than even get into that area, we're going to say, you know what? No, you don't have to accuse yourself. We will look for other evidence, what's called circumstantial evidence, to put together a case. So, kind of finish out that analogy, and we'll keep moving forward. Excuse me. Let's say that there's a muddy path between the two neighbors, and it's very obvious to anyone that would look that the day before there's no footprints, and then the morning after the alleged goat theft, clear footprints from the neighbor's house to the other neighbor's house, and then following, tracing back footsteps now with little goat hoof prints, right, coming back. Circumstantial evidence. We didn't see, no one saw that happen, no one saw that take place, but compiling the evidence together, let's see here. Footprints going from the neighbor's house to the neighbor with the goats, and then reverse footprints coming back to the neighbor's house with goat footprints coming in that same direction. Maybe that's sufficient, right? But that would be evidence to point to that wouldn't necessarily rely on the thief to accuse himself. Again, we know people lie. We know that's a general principle. We live in a fallen world. So rather than try to make this pretend idealistic, of course he wouldn't lie. No, we just presume that, look, you're not going to have to accuse yourself. So what happens then is we take that principle of law, and it's baked into the Fifth Amendment, right? Again, pop culture, any kind of, crime show, attorney show, anything you've probably ever seen, maybe like 70 to 80% of the time, probably references, I plead the Fifth. Have you heard that before? Have you heard that phrase, I plead the Fifth? What does that mean? Well, the Fifth Amendment provides people, persons, with the right to not be a witness against himself. So Amendment 5, no person shall be compelled in any criminal case to be a witness against himself. Same principle. It should cook now into our Constitution in the Fifth Amendment, as well as, of course, several other components in the Fifth Amendment. But for our purposes here, this idea of self-incrimination is largely what the Fifth Amendment is there for. It's baked into this principle of, look, we know people lie. We're not going to ask them to accuse themselves of a given crime. We're going to provide that as sort of a baseline understanding of accusation. And we're going to say, you know what, guy, whoever you are, you don't have to incriminate yourself. So plead the Fifth. Quick caveat, and really the next point. If that person ultimately decides to incriminate himself, that's also his right. He can also do that. So in other words, let's say this guy, the goat guy, and I just so we finish up the analogy, and I do need to be moving on, but it's important to understand this. Let's say he is there in front of the judge, and whatever, the prosecutor or whoever to be asked the question, did you take the goat? That man could very well say, by golly, you know what, I did take the goat. I knew I was going to take the goat, and I thought about it for a long time, and that night I went over and I took that goat. Those are my footprints. Those are the goat's footprints. Actually, here's the goat right here. It's actually standing right next to me in the court. He can do that. That's his right, but it's up to him to waive that right. So in other words, it's given to him immediately. We don't have to self-accuse ourselves, right? We don't have to point the fingers at ourselves. We can say, I plead the Fifth. That's a protection that the Constitution provides for, that comes from antiquity, back in English common law. But if the criminal suspect or defendant ultimately decides to incriminate himself, then by all means, that could be used as evidence. And it's pretty strong evidence at that, right? Who in the world would lie about doing a crime? That just really baffles the mind. So if a confession is written out or said by the person accused, that typically moves its way to the top of the stack of evidence that the prosecutor, the state, whoever it is, would present to, again, the judge, the jury, depending on what sort of trial we're looking at, but more times than not, the jury, to say, hey, look, this guy said he took the goat. So he probably took the goat, therefore render a guilty verdict, right? Keep moving on. But all that to say, I'll couch it here, the Fifth Amendment comes from this legal principle that no man has to accuse himself. All right, so let's get into the history of Miranda v. Arizona. Gideon v. Wainwright. And all these cases, I think, are like within a 3-year span. We're about to cover 3 cases. So we're kicking off in 1963. Okay, so again, important, I think, for historical context. I am by no means a historian, but it's 1960s, civil rights, feminism is coming through. We have the Vietnam War, just an incredible amount of threads are coming through our society. The sexual revolution, we have the music that's coming out, the art and literature, postmodernism thought. I mean, all sorts of things are happening to our country and just flooding it seemingly all at once. So it really shouldn't be a surprise that things like criminal procedure or rights afforded to the accused are also reevaluated, right? Deconstructed, contemplated in light of I can never say that word, modern times, modernity. That still didn't sound right. In light of modern times, what are we going to do about the accused? So in other words, we're not back in the Stone Ages and we just, you know what? I think he stole the goat. Lock him up, throw away the key. We're not going to do that. So, Gideon v. Wainwright. Excuse me. So, Mr. Gideon, I believe, charged with a state felony of breaking and entering. So stole some stuff. Someone saw he had some of the stuff that was allegedly stolen. He gets teed up, gets his day in court. But he says, wait a second, I have the Sixth Amendment. What does the Sixth Amendment say? I'm so glad you asked. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So he basically waives the Constitution in court, in the trial, to say, wait a second, guys, I have my Sixth Amendment right to counsel. I don't have an attorney here next to me. On the other side, the prosecution is just bombarding me with legal jargon, expertise, knowledge about how the legal system functions. And so he basically pleads to the court, in open court, to say, I need an attorney. What does the court say? The court says, sorry, you don't get an attorney in these cases. So namely like a state felony. It's only, I think, capital cases is what they said, which I think is the next step up in the Florida scheme. But really, regardless, the court said he did not qualify for an attorney. So even though he couldn't, if money was no object, right, he could definitely hire out the best legal defense team, in theory. But he couldn't afford it. He couldn't afford it. And so he said, Sixth Amendment provides me the opportunity to have an attorney. Court says, actually, no, it doesn't. Florida law would say only in these certain cases do you have the right to an attorney if you can't afford one. So try again. Good luck defending yourself against the state, who has, again, professional attorneys that prosecute and litigate all the time against these sort of things. And so he's found guilty, and he's thrown in prison, and he tries to appeal his case, and he gets all the way up to the Supreme Court. He actually has a law library in the prison and is able, I think, to write, it was like pen or pencil or something in like stationery, and made this argument to the Supreme Court to say, hey, guys, look at my case. Look at this deal. Look what happened here. I had a constitutional right to have legal counsel, legal assistance during my trial, and I was not afforded that. So because, again, Marbury v. Madison, super important. Because my constitutional right was infringed upon by this law or this procedure, then I should have the right to a retrial. I should have a right to get a do-over, this time with legal counsel. Why? Because, again, the law violated the supreme law, the Constitution. So he makes that argument to the Supreme Court. And they say, yeah, that's a really good point. They ultimately held, the Sixth Amendment requires the United States, so the individual states, again, we're talking about Bill of Rights typically only applies to federal government, but through the 14th Amendment, now the Sixth Amendment is going to apply to states, such that states have to provide criminal defendants with attorneys if they are unable to afford the attorneys on their own. Wow. Okay. So, little guy, right, fighting Goliath, fighting the entire legal system, wins out. Pretty cool. Unless you go and kind of fast forward and look at his individual rap sheet and what actually happens to him later on. So I'll leave you that. If you're interested, please go look it up. But for our purposes here, the Constitution all of a sudden provides that states, individual states, so like Florida in this case, or Texas, Oklahoma, Washington, California, North Carolina, South Carolina, wherever you are, now has to provide you legal counsel in any criminal trial if you cannot afford it. It sounds reasonable. I think it is reasonable. I kind of want to lead you there right now to think of this as reasonable. What I'll put in the back of your mind, though, is point out in the Constitution now where it says that states have to provide legal counsel in all criminal prosecutions. Not a big jump, but it is a jump nonetheless, and we're going to keep jumping. So as the court looks at, I don't think I had you read this case, but basically the concept that we take away and kind of carries with us to the next two cases is that there's a fundamental and essential right to have assistance of counsel during criminal matters. And that makes sense, right? The law is not simple. A lot of the clients I even have now will come to me thinking that it's just a shortcut, super simple solution, and that's all they need. So it shouldn't take that much time, shouldn't take that much brain power, shouldn't take that much work. When in reality, it gets complicated very, very quickly. So now imagine that we're talking about your livelihood, right? Your life and your liberty is on the line. You've been accused of a crime, really regardless of innocence at this point. You've just been accused of the crime. How in the world are you supposed to navigate process, procedure, legal arguments, let alone all the sort of intangibles that come with not being an attorney, not being legally trained? How in the world are you supposed to represent yourself when it's not even a petty situation? You know, again, going back to the goat situation, if that was an issue now, there's what's called small claims courts. The justice of the peace could handle that. And it's not to say that it's unimportant. It's just to say that courts actually stack themselves up in certain ways depending on the nature of the issue. So like a criminal issue, civil issue, we've kind of talked about that bifurcation before. But in this case, this guy is going to get locked up for a very long period of time if he's convicted of the crime he's accused of. Now, again, I kind of alluded to it, but like, if he actually committed a crime, who cares, right? Who cares? He's going to hopefully get found guilty by the legal system. We can move on with our lives. We get a criminal off the streets in prison. Now, another can of worms there. What do we actually do with people that have broken the law. I don't think we really get into that, but that would be a fascinating topic of conversation, if not an entire semester as well, to think about that issue. Okay, you've broken the law, right? And we know that for all have fallen short, right? We will always miss the mark. So when we're dealing again with common law and we miss that law, what is the punishment we deserve? Right? We know as Christians that we've fallen short. We deserve death. God is a perfect God. He's a perfectly good God and has no allowance for sin. Okay, so then what do we do with criminals have broken the law? Right? Really, really interesting question there. But let's just fast forward real quick to, again, the Gideon v. Wainwright case. This guy's got a lot on the line. And so the court looks at that and says, you know what? Yeah, actually, we do need to provide legal counsel, because otherwise we're just depriving people of their liberty and life at sometimes left and right. So, you know what? Yep, it's a fundamental and essential right to have an assistance of counsel, and that's going to be applied via the Sixth Amendment. You get to have assistance of counsel, and then through the Sixth Amendment, through the 14th Amendment, gets applied to the states. Awesome. Let's keep trucking along. Okay, Escobedo v. Illinois. It's like a year later, I think. Yeah, 1964. So here, the suspect, Escobedo, is arrested, and he actually makes the case that, look, I need my attorney. I have one. It's not even a matter of whether I can afford him. It's I have an attorney, so I'm not going to talk about anything until my attorney's here during this police interrogation. So probably another pop cultural scene. Again, I wish I could have compiled a list. Probably it's not necessarily a good thing to go and watch some of these episodes or TV shows or movies, whatever else it might be, but maybe you can picture some off the top of your head right now too. Okay, you're in the kind of dark room, right? There's the police officer that comes in. It's a metal table, an uncomfortable chair, low light, but the light somehow is always shining right in the suspect's face. And then maybe there's a little good cop, bad cop routine, and there's that that two-way or that one-way glass mirror thing, and all that kind of stuff, right? So that's kind of what we should be picturing right now, is in police custody. He's being interrogated for a crime that he is suspected of committing. But the defendant says, hey, I need my attorney here. And law enforcement basically deny him that and say, nope, not going to happen. I didn't research this too much, but his attorney may have even shown up to the station where the defendant was at, requesting to see his client, saying, hey, I'm here. So it's not even a matter of getting the communication to the attorney. Like the attorney was there saying, let me go see my client. The defendant, or the suspect, I should say, is also there saying, hey, I need my attorney. And so ultimately the law enforcement, the state, right, the government, Illinois government, getting down to wherever police department was operating under, denied him that right. Denied him the right to see the attorney. And so that issue got all the way up to the Supreme Court again of, wait a second, Sixth Amendment, we just said that if a criminal defendant couldn't afford a attorney during his trial, then the state needs to provide one via the Sixth Amendment. So now we're dealing with police interrogation. So we're not to trial yet, right? Keep those separate. The man's been arrested. He's in police custody to be interrogated. Again, going back to the evidence theory, right? We need to prove up and demonstrate and show that this suspect, Escobedo, committed this crime. And if we can get him to say, I did the thing, right? I committed the crime, then that evidence is so much more valuable in the prosecution of him, right? As he's being prosecuted, to slap down in front of the jury, he said he did it, than anything else. So in police work and law enforcement, it's to their advantage to have criminals say, I did the crime. I committed the crime. Makes life a whole lot easier, because then otherwise, again, we're going to have to go and look at circumstantial evidence. We're going to have to start looking at, witnesses, right? We're going to have to start asking around, hey, did you see Mr. Escobedo at this time on this day? So the concept of alibi comes in, right? If someone else will vouch for you that, well, no, I was with you at this time, and that's at the same time that this crime was committed, therefore you couldn't have committed it because I was there with you. The kind of the DNA test, right? If you got into any kind of like true crime podcast, that seems to be a big fad or kick or whatever else may be. Law enforcement is ultimately have to line up certain points of evidence to get to the general claim that this person committed this crime, and then prosecute him accordingly to convince the jury that, yes, this person committed this crime and then should be found guilty and serve his time, right, or pay the punishment, or whatever else the punitive damages may be. So, again, to kind of give back to this case, if the police officers and law enforcement think that this guy committed the crime, and let's just suppose, too, that all the circumstantial evidence also points to this guy did the crime, and there's other people that are saying this guy did the crime, then it'd make everyone's life easier, except for Escobedo, to just say, yeah, you know what, I did the crime. So if an attorney gets thrown in there, well, the attorney should know about the legal rights afforded and which question he can answer or doesn't need to answer, or when he should just generally remain silent until they don't have anything to hold him on. So in other words, if there's no threshold and they can't get to any sort of certainty as to why they can place him under arrest and keep him within custody and not have any sort of outside help, not go and try to get bail posted, anything like that, then the police officers, in theory, can do their job better by just getting this guy to confess to the crime while he's there. Then they can have that, and then they can release him, and then they move on with their lives. So in this case, though, Escobedo has the attorney and is making the request for his attorney. And I think, like I said, I didn't research it, but I think the attorney even showed up, too, and was there to say, let me see my client. And law enforcement was ultimately saying, no, not going to do it. So he's convicted. Again, goes all the way up to the Supreme Court. Supreme Court decides that criminal suspects, they hold that criminal suspects in police custody also have the right to an attorney as provided by the Sixth Amendment. Okay, well, that I think also makes sense. It kind of, I'm okay to say that. It's almost more important, and I think the court points this out too, during this time when the suspect is first arrested and is held in police custody, to have legal counsel and legal help to help navigate through that whole process. It's even more important than when we get all the way to the trial, when we're actually in front of the jury and the judge at that point, because so much is happening. So much is happening during this time that will be brought up in trial, that if you don't get this stage of the criminal procedure right, then it really won't even make a difference later on. They have to get all their evidence, all their ducks in a row, all their boxes checked here to be able to use, hopefully, that confession, again, that self-incrimination, later on in trial. So the court's looking at all that and says, you know what, that's a pretty substantial right as well. So any statement, any statement that's elicited under such circumstances, namely when there's no attorney present and he's requested an attorney, he's invoked his Sixth Amendment right, then we're going to throw out that statement. It doesn't count. We're going to use it as evidence. It touches more on evidentiary procedure for our purposes here. Think of it as coercion. Think of it as, again, you're like locked away, just, again, picture the scene, right? The most egregious police interrogation you've ever seen on TV or in a movie show or something. The Batman scene comes to mind. That's maybe a decent example to use, where the Heath Ledger Joker is locked up, and I don't know, maybe the city's about to blow up or something, and they try to do the good cop, bad cop, right? The law actually comes in and tries to get the confession, and then what happens? Batman's like in the shadows, ready to like slam his head on against the table, and that's kind of the bad cop routine. Obviously Batman's not a cop. All this is fictional anyway. But if we imagine that same sort of scenario, except it is the law, right? There are good cops and bad cops. There are intimidation tactics. There are strategies being used, as the Miranda case gets into, to get a certain suspect to, I did the crime. Makes their job, police officer's job, a lot easier. But now this guy may have very well just ruined his life by confessing to something that he may have not even done. That's the other thing the court looks at too, is sometimes, and especially way back when, there would be certain torture tactics used to elicit a confession just so, okay, at least they have a guy. And so, do we really care about innocence? No, we care about locking him up and throwing away the key. So crime was committed. This guy seems like he did it. Beat him up until he says, you know what, I did it. Okay, please stop beating me up. I did the thing. Great. See, he said he did the thing. We can move on with our lives. Time moves along, right? We get to the point of being able to plead the fifth, having a speedy and public trial. Very important constitutional right there by an impartial jury. All those sort of principles of law that we want in a fair and just society are demonstrated, I think, most apparent in our criminal courts and our criminal procedure. So in this case, again, we're in the dark room, good cop, bad cop routine, sleep deprivation, food deprivation, any number of tactics could have been employed. We don't need to speculate on it, but just, again, trying to set the scene here. And so the court is going to look at that and say, look, any kind of confession that comes out of that scenario, especially after he's already said, look, I need my attorney here, we're going to say that's not good evidence. We're going to say that, look, that didn't cut it. That is not going to meet that evidentiary burden to be admitted into court. And so we're going to throw that out. So you have the right to an attorney, even if you can't afford one, at trial. And now you also have the right to an attorney during the criminal interrogations when the police has you in their custody. So now, that's all set the stage for Miranda v. Arizona. In this case, very similar facts, right? Some guy did something, a crime, actually a pretty egregious crime here, is accused, is arrested, has gone through the interrogation process, a confession is received, they elicit a confession from him, the law enforcement elicit a confession from him, he signs off on it, and he's found guilty. I mean, it's almost, it's kind of sad for me to say this, but I think it's important to recognize that this is sort of a run-of-the-mill criminal. This is kind of a run-of-the-mill crime that's committed. So there's nothing particularly fantastical about this procedure. What happens, though, is that they are able to challenge the procedure that took place. Again, from arrest through interrogation to trial, that ultimately makes this such a landmark case. So the issue is now whether the Fifth Amendment protection against self-incrimination extends to the police interrogation. Okay, so we know in trial, court's going to provide, or the state's going to provide an attorney for the accused, even if he can't afford one. We know that you have a right to the attorney during the police investigation, and so now what do we do with the police investigation and the concept of not having to incriminate oneself. In this case, it was, I think, several hours of these sort of intimidation tactics or what else could have been used to ultimately elicit this confession. But it's worth pointing out that this guy, one, should have an attorney, and two, had the right to not incriminate himself, to not have to say anything or answer anything to these guys' questions. So the court kind of does a weird analysis here. It's tough for several reasons. One, because I think their ultimate conclusion is not bad. It's not a, where did that come from? But at the same time, too, there is sort of a legal, what do I want to call that? They're legislating from the bench. They're looking for policy reasons as to support their conclusion rather than looking to precedent. That's probably the best way to say it. We saw that in a number of cases before where it's like the court puts out their conclusion, they're holding, and then says, okay, now we're here still now, right, in the background. How are we supposed to get here to our conclusion, to the foreground? And I think that's what happens in this case too. They're basically looking at this issue of the Fifth Amendment, this idea of self-incrimination, that criminal defendants do not have to incriminate themselves. Of course, they can if they want to. That's fine. But they're looking at the circumstances in which Mr. Miranda here confessed. And so they look at the police manual, right? They look at all these tactics that are used during interrogation. Let me see if I can flip over here real quick. Yeah. Okay, to be alone with the subject is essential to prevent distraction and to deprive him of any outside support. The aura of confidence in his guilt undermines his will to resist. He merely confirms the preconceived story the police seek to have him describe. Patience and persistence, at times relentless questioning, are employed. To obtain a confession, the interrogator must patiently maneuver himself or his quarry into a position from which the desired objective may be obtained. When normal procedures fail to produce the needed result, police may resort to deceptive stratagems such as giving false legal advice. It is important to keep the subject off balance. For example, by trading on his insecurity about himself or his surroundings. The police then persuade, trick, or cajole him out of exercising his constitutional rights. So this was, it's tough. Like I said, it's sad perhaps to see this sort of manipulation occur, but it's law enforcement, right? So law enforcement needs to get criminals out of society lest they commit more crimes and harm and injure more people. That's why we have laws in the books, right? That's why we have enforced social contract theory. All I have to say, though, is if we are sort of operating under the guise of whoever's sitting in that chair across from the law enforcement is innocent, right? Innocent until proven guilty, another kind of fundamental concept of law, then what are we supposed to do with all this manipulation and these strategies that law enforcement has developed to get someone to confess? It's a really tough question, right? Because at one end, if we just could know, okay, that guy's criminal, and he did this sort of crime, it doesn't really matter. It doesn't really matter how he gets to confess, because it's a whole lot easier then to get the confession, run him through the speedy and public trial, lock him up, and throw away the key. Okay, but if we don't know he's committed the crime, and we truly operate from a place of this man could be innocent, I mean completely innocent, then what are we supposed to do with these manipulative interrogation strategies? Right? What are we supposed to do with those? What sort of rights and balances need to be in place to counteract the power that the police officers have to elicit that sort of confession? So the court looks at all that and they consider it, and they look at it holistically and say, you know what? Basically, these criminal suspects have to be informed of their right to remain silent, know that anything they say can and will be used against them as evidence, right? As evidence in the court of law, that they have the right to have an attorney present, and if they can't afford that attorney, one will be provided to them. So the court basically balances it out, right? Legislates from the bench to say, look, here's what we're operating under. We have little old criminal coming in, alleged criminal, right? Could be completely innocent. We don't know. That's why we have the legal system and criminal procedure. But we have the little old criminal coming in. And then we have the weight and gravitas of the United States judicial system and its law enforcement agencies bearing down with these tactics and strategy to elicit little old criminals' confession. Court steps in and says, nah, guys, what we're going to have to do now, based on, you guessed it, the Constitution, is you're going to have to inform them of their rights. Anytime they're now in your custody, you have to inform them of their rights. And so what that means then, too, is as soon as they invoke their right to remain silent, namely not to bear witness or accuse themselves, interrogation over, stops. So no more of this dilly-dally games that they play to, I guess if you were innocent, then you'd let us know. But if you just want to remain silent, then, man, you know how that looks. None of that stuff, right? Interrogation's done, at least in theory. That's how it's supposed to work. Right to remain silent. Anything you say, the police officer now have to tell them, anything you say can and will be used against you in the court of law. So anything, right? Anything you may say. You may not think you're saying anything about the crime. You get dumb criminals all the time, right? People are dumb. Criminals are people. Ergo, there are some dumb criminals. And they say things like, I don't need examples here, sorry. Let me back out of that thought. They will say things that will lead the police officers to use that as circumstantial evidence. So they may happen to mention how they saw that green car driving by. Well, wait a second. You said you weren't there. How did you know it was a green car? Oh, well, that's now circumstantial evidence, right? It's not a confession to the crime, but it's offered to lend support to the thing. It's more likely than not to lend support to the thing that's being that the prosecutor's trying to prove. And then finally, the concept of the attorneys, right? Covered that in the previous two cases. The importance of having attorneys present both during the police investigation or police interrogation and the trial. And so as soon as a criminal defendant or suspect, I need to get those terms clarified, but suspect here, has just been arrested, going through the procedure now, has a right to get an attorney. And if he can't get an attorney, guess what he can tell the police officers? Get me an attorney. Right? That's a constitutional right that's now been created as applied now to any any state criminal matter through the Escobedo v. Illinois case. And so now Miranda basically just takes it a step further and more or less replaces that holding of saying, look, you have to afford all these rights to these criminal suspects now. And if you don't afford these rights to them, if you don't read the rights, or if you violate those rights, then any sort of evidence or any sort of testimony or confession that it's elicited from that interrogation, we're throwing it out. We're not going to deal with it. I think there's one more little. Just read that one. Yeah, this one. It is obvious that such an interrogation environment is created for no purpose other than to subjugate the individual to the will of his examiner. This atmosphere carries its own badge of intimidation. To be sure, this is not physical intimidation, but is equally destructive of human dignity. The current practice of incommunicado interrogation is at odds with one of our nation's most cherished principles, that the individual may not be compelled to incriminate himself. Again, the Nemo principle. Unless adequate protective devices are employed to dispel the compulsion inherent in custodial surroundings, no statement obtained from the defendant can truly be the product of his free choice. Look at all that case law they cited, by the way. Yeah, none, right? They are basically putting together theory and legislating accordingly, but from the bench. Again, they're supposed to say what the law is. It's emphatically the providence of the court to say what the law is. Not what it should be, not even what it could be, just what it is. So that is the big pushback from the dissenting opinions. This was a contested case, right? There's a lot to be said here. The dissenters basically point out and say, okay, guys, you know what you're saying, I think generally makes sense. Look, if we just know that people are being, battered over the head left and right to get these confessions, then yeah, probably something needs to be done about that. But where in the world in this document does it say anything about having to read those rights to the suspect before any of that testimony can be used in the court of law? It's just not there, right? It's just simply not there. We're basically building this tower and these rights out of the Fifth Amendment and the Sixth Amendment. So again, the baseline principle that we already had, the nemo intenitor, you don't have to incriminate yourself. And then you also have the right to have the assistance of counsel. But otherwise, the thought that it's a constitutional right that the police officers now have to inform their suspects of upon arrest, upon bringing them into their custody, it's nowhere to be found. It's nowhere to be found in the Constitution. What's another issue that the dissent, at least one, points out? Well, let's think about this. How do we go from, bad guy stealing the money, police officers are in pursuit, to bad guy in jail? What happens, right? What happens between... Wow, cannot stop coughing today. What happens between the crime itself, right? The crime as it's happening to, again, in theory, gets caught, arrested, thumbprinted, photo taken, whatever else, that we see in the movies, right? Important concept. We've seen the movies, to he's actually in prison serving time for the thing that's happened. Well, one important thing that happens, if I can get back there, is the actual trial, right? The actual trial has to take place. Sixth Amendment, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. So it's not enough just to, I saw you doing the thing, the guy's running them down, but there actually has to be a trial. And then how is evidence compiled for a trial? Well, the police interrogation is one way to do that. Talking to witnesses, looking for like the DNA evidence, if that's pertinent to the case, looking at bank records, right? Looking at photos, looking at other documents. Again, if you're a true crime podcast person, if that's kind of your thing, I'm actually not sure if that's where we're situated here on age range. But if it is, fantastic. You may know kind of what I'm talking about here. Otherwise, just think about this concept here of, okay, the crime is committed, but something has to happen before the guy is actually put in prison. Okay, so that's something we're going to call criminal procedure. Very important, super important, right? We're not just going to say, I think you stole the goat. I'm accusing you of stealing the goat. All right, go ahead and throw him away, right? Go ahead and put him in prison, lock him away. Now, sure, again, it depends on who the accuser is and who has been accused back in the day. But now, where we're situated, and especially coming out of the 1960s, is criminal procedure is very, very important. So the dissent points this out. Not as a bad thing, but look, you're throwing one more thing within this purview of criminal procedure. In other words, you're about to hamper law enforcement's efforts all the more by giving them one more thing that they have to think about and worry about while trying to administer justice, right? Trying to keep our society safe by serving our communities. You're throwing one more thing at them, and there's already this huge obstacle, this huge roadblock in the way of the crime happening to serving time or paying the punitive damages, whatever else it may be. I think it's a decent observation. It's not to say that it points out any sort of inherent fallacy, perhaps, with the court's reasoning, but it is an important concept. Again, we already made the point known on the last slide that it's not in the Constitution. It's not there, but yet we're going to say it's a constitutional right now. These Miranda rights are constitutional rights, going all the way back to the no food in the kitchen, right? Here's the law, no food in the kitchen. We saw even then how all of a sudden food's now somehow allowed outside the kitchen, even though the law says no food in the kitchen. It's more or less the same concept here, and the court's pointing that out, but in this particular second point of the dissent, is they're looking at it and saying, look, we're adding one more thing to this. We're adding one more roadblock in the way of police officers just trying to do their job, trying to keep our society safe, protect and serving our communities. You're throwing one more thing at them, and not to mention the fact that it's just not in the Constitution. We're just overstepping our constitutional bounds by legislating from the bench. So that's Miranda v. Arizona. Very important case, again, predicated on the Gideon v. Wainwright case. We want and we really need the assistance of counsel at trial, especially if one criminal defendant cannot afford an attorney. The court comes down and says, yep, state, you got to provide an attorney to folks that are being prosecuted as criminals. If they can't afford one, move forward a little bit. Next year, we get the Escobedo case v. Illinois. Same sort of concept with the Sixth Amendment, but now we're applying to police interrogations. And then finally we get the Miranda case that says, look, you got to provide these rights. You got to inform the criminal suspect of his rights to remain silent, that anything said in this interrogation will be used against him in a court of law, be used as evidence, that he has the right to an attorney, and if he can't afford an attorney, then one will be provided to him. Those rights have to be said to and given to the criminal suspect there, and it's ultimately his rights then to waive. So again, if he decides to start blabbering his mouth, that's his prerogative. But he has the inherent right now, via the Fifth Amendment somehow, to just remain silent. Just stop talking. And as soon as he stops talking, interrogation over. And likewise, as soon as he says, I need an attorney, interrogation stops until an attorney's there. So, all to say, I know I'm way over time. All that to say, criminal procedure, very important. Court expands the rights of the accused through these cases and ultimately provides more protections by broadly interpreting the Fifth and Sixth Amendments within Arizona v. Miranda. A lot of implications still, right? A long ways away from this case. A lot of more development. If you are curious, please go and research that further. As always, please continue to ask questions. Dig into the material, wrestle with the material, cross-pollinate too, right? So important to look at these different concepts and see where you're seeing these other concepts in your other classes and be able to have these conversations throughout your school, church, community, families, wherever else may be. So anything that's sparked, love to know your thoughts on it and any questions you may have. So I'll see you next time. I pray that you have a blessed week, and please take care in the meantime. Thank you very much.